Registry Matters is an independent production. The opinions and ideas here are that of the hosts and do not reflect the opinions of any other organization. If you have a problem with these thoughts, FYP. Recording live from FYP Studios East and West. I'm back in my own proper place, transmitting across the internet. This is episode 74 of Registry Matters. Larry, it's Saturday, and we are having a party because obviously that's what people should be doing on Saturday nights, is they should be recording a podcast.
I think that's a great thing for people to be doing. We do it every week for the last 74 weeks.
We have, we missed a couple in there somewhere, but we'll let it go. So 70-something weeks we've done it. I did,
you know what, though? A Saturday.
I think so. I think everybody should be joining in on live stream and harassing me with crazy questions or something. But someone over on Twitter said, why don't you guys ever take a week off? I was like, because there's lots to talk about every week. Plus, we could record any day. It's just a couple hours. I don't really see the necessity to take a break at any level of regularity.
Well, there's a little more than the recording time. There's the accumulation and prep time. But yeah, I get the point. This is not our full-time job. If it were, we would be going broke really quick.
Well, yeah, that's true. I don't think I could pay my rent on what you pay me.
And we're going to have to cut that if you don't improve the performance.
Oh my God. I didn't realize that this was performance based. Hang on. Wait a minute. When is my annual review and what are the metrics?
Metrics are we have to exponentially increase our listenership at our patron level.
Hey, that's a perfect segue. We have 2 new patrons this week, Larry.
I've heard about that.
We have a Christopher and we have a David, which David, because David's a very common name. I'm just going to let it go. I'm not going to call it your last name because we have about 12 teen Davids on the list. So you know who you are. And I can't thank you guys enough.
I can.
Okay, well, we'll begin.
I can thank you enough. All you have to do is give your net pay. And
we're back to that. All right, then.
Oh, so one of these days, someone's going to create a dummy paycheck because it's easy to do. You could create a fictitious employment, and someone's going to create a paycheck, bring you home like $25 a month or something, and they're going to say,
"That's true, right?
You said you wanted the net pay. Here it is."
I'll tell you how somebody could do it. Is they could, if they put in some BS number, but someone could create the account. They're not going to get charged until the end of the month, so you could come in and pledge to give me the $1 million per month, and then it just would, you cancel the account right before it charges, and everything goes away. Everything's fine.
I'd be surprised if that cleared the processor on a $1 million donation. Very few people have that type of credit or debit available.
I know, but it doesn't do it till the end of the month. So somebody signing up today, they're not going to get billed for 3 days, but come May 1st, you're not going to get billed for 31 days.
You'd think that maybe that's such a ridiculous number that the metric of the system wouldn't even let you enter that.
That is very, very true.
It's kind of like the claiming exemptions for the IRS. There's an amount, and I forget what it is, but if you claim too many exemptions, the IRS will contact your employer and say, we need documentation that they're, because you can't, there's only so many exemptions you can have. There's a limit to how many offspring you can create.
Okay, so they'll track how many kids you can create, but Paul Manafort buys, what were they, ostrich jackets and launders hundreds of millions of dollars, and he never gets caught?
Well, I don't know if that's the same analogy, but withholding is fairly well controlled, and we've got systems that are in place for a long, long time for tracking withholding, and the IRS kind of has that down to a science. Very well.
Well, let's start jumping into these articles because someone criticized us for having too much beginning banter. This first article comes from WHYY, and Congress considers making college more accessible to people in prison. Can you believe it, Larry? There have been studies done that the more education you have when you get out of prison, you are less likely to go back. And this would ultimately, even though we would spend money on the Pell Grants, they would have reduced costs on the backside. I'm shocked. This doesn't even sound like it could be true.
Well, I'm shocked as well, but I think we omitted to introduce that we have a couple more people that are going to be participating tonight above normal, you and I. So,
well, I figured we would introduce at the end, but we can backtrack. Okay. We do have a guest from the northeast state of Vermont named John. John, say hello.
Hello.
Well, welcome.
Hey, I feel welcome. Thank you.
I'm glad.
And And then we have another one, don't we?
We have two more, but they're just hanging out listening. They're not here to speak.
Okay, all right. So we've got. So is John's last name Sanders?
No, I don't think so.
And track it.
Is there a Bernie Sanders brother?
There might be, but it wouldn't be me.
All right, but on this, go ahead with your question.
Well, can you believe that we would actually do some sort of studies to find that people getting out of prison, if they have more education, that they have more opportunities, and thus on the backside, I think it says that the estimates to increase the spending would be about $40 million, but the return on investment would be $300 million?
I'm always dubious about those calculations for return on investment. But sometimes I tell people I'm not interested in all those predictions. I'm interested in doing the right thing. It's the right thing to do because society, to me, is better off if we have people who are better equipped to participate and compete in a capitalist system when they come out of prison. So I know that this was a restriction that they put in place back in the tough crime days in the 90s. Yes. And then I think Obama tried to relax it back in his administration, and perhaps now we'll make some real progress because it's kind of like when Harry Truman was president. Anything he tried to do in his second term was bad because it had his name attached to it. That it was easier to call something the Marshall Plan than it was the Truman Plan. But right. This is something that's well past ripe for discussion to use prison time to rehabilitate people.
But on the back, so going back to the 90s when this was signed in, there's just this whole mentality of like the super predators, that term came out at the time, and just like, okay, you did your crime, you're now in prison, and that like they started taking out any sort of recreational things. I guess it got popular to talk about that they're just sitting there watching cable, and just to keep beating people with sticks and reducing access to any sort of resources and any sort of rehabilitation to help you on the backside. It's bizarre.
Well, it looks like this has bipartisan support. Both Democrats and Republicans had a hand in the tough on crime policies, and now it looks like that this is also enjoying some bipartisan support.
Don't you often yell at me for this is all about the bipartisan support that you like?
Well, I don't think that's the way I intend it. What I intend to communicate is that just because something is bipartisan doesn't mean it's good.
Okay.
It's kind of like just because you don't like something doesn't make it unconstitutional. Just because bad policies can enjoy bipartisan support, that would explain the registry and our tough on crime. But reforms where you're actually relaxing bad public policies, you need bipartisan support, because if you don't have that, then you're going to end up with one side vilifying the others. You have a great political vulnerability. And that's where when you have bipartisan cooperation, then you can say this is not anything. This is not liberal conservative. This is sound policy here. This is bipartisan policy. But that's the one I'm trying to communicate, is that bipartisanship in and of itself is not necessarily a good thing. But there's times when it's necessary.
I understand, and I agree. Let's head on over to Baltimore, where I don't know how this guy actually survived. How did the police shoot at a guy 44 times? And forgive me for the way I'm going to be blunt. How does this guy not die?
Well, I think they hope he does or did from the article.
And it's an incredibly long read. It's from The Intercept, and I think where you're going to go after this is about prosecutors. This guy has been either like hung juries and just on, and the prosecutors just keep going back. And all this evidence continues to come out, or has continued to come out, calling into question that this is the guy that committed the crime that they're alleging he did.
Well, I'll have to confess, I didn't read every word of the article. I think I'm the nut that put it in here. But
probably,
I'm pretty sure I am. But I put it in here to show the zealousness of the system. They made a mistake in shooting him to start with, by all accounts, and then they're trying to make some justification for but they've settled civilly. If I read the article correctly, they've settled. They've paid out a lot of civil on this, haven't they?
I think so, yes.
Have I got this confused with another article? They've paid out a whole bunch of money, but they continue to stand behind their mistake, and they continue to try to put this man in prison.
Hey, Larry, can I ask you a question
Go
about
ahead, John.
this?
Sure.
Why is it whenever we have these shootings and whatnot that the minute the city settles with the victim or the victim's family, that seems to be the end of it, and we never hear about either anyone, admitting to anything. It's usually all swept under the rug. But when you're talking about bullets and blood and people being shot, like, why does a civil lawsuit signal the end of these kind of issues?
Well, I guess that's because it generally is the end. If someone gets killed and the city or the responsible entity settles, what else would there be to do other than prosecute the people? We know that from experience of watching prosecutions of law enforcement, they're very unsuccessful.
Yeah.
It's very difficult to get a jury to convict, and that's even in the most liberal jurisdictions. You had trouble. They tried to convict. Was it Freddie Gray, the van
Right.
rough ride?
Yes.
They tried their best. Prosecutor Mosby, I believe her name was, tried her best to convict. And we had the same thing here in New Mexico with the shooting John Boyd off the mountain here with the Albuquerque Police Department. Former DA Kerry Brandenburg tried to convict those cops, and you just can't. So I mean, when you do those, since the civil burden is lower, you remember it's a preponderance of the evidence,
Right.
which is slightly more than 50%. The O.J. Simpson would be an example of that. You got an evidence sufficient to win a civil lawsuit, so therefore they settled. But trying to hold someone criminally responsible is very difficult. Particularly, there's an elevated standard for the cops. It seems like the citizens that sit on the juries will give more benefit of the doubt to the police officers because they're in the line of duty and they're putting their life on the line every day. And if it weren't for them, we would be no telling what kind of conditions we'd be living in. So it's very difficult to get a jury to unanimously return a verdict.
Yeah, I guess it just seems that if a person, were to another person, the city wouldn't stop, once that person was willing to settle and pay that other person. But because it's the city or it's an employee of the city, in this case, a cop, all of a sudden, a civil lawsuit, it's your wipe your hands and kind of walk away, nothing to see here. I don't get it.
That's kind of what it is. There's nothing to see because you can't bring the person back and you can't convict anybody of any wrongdoing. And it's even difficult even to fire police officers. It's exceedingly difficult with the union rules that they have, and police unions are like no other union. They really are in terms of their power. That's the one union stronghold that still enjoys broad support. Most people in America, they could care less about union organizing and about collective bargaining. But when it comes to the police union, oh yes, we support the police and their union.
Something else that came up in the article, which I think is just indicative of the mindset, is that the I guess it would be the victim's mother. So, and I'm not referring to the victim of the guy that got shot 40 times, but the person that was actually killed. His mom says, like, it's a victory, and I'm like, this isn't necessarily a victory if justice wasn't served. It's the wrong. It feels to me it's the wrong attitude about the judicial process. This isn't a victory. Like, everybody loses in this whole situation. Nobody's actually like a winner.
That is correct. But like I said, I don't really know why I put this in there other than just to show the dysfunctionality of our system, and we've got a lot of work to do. And when we illuminate these things, it's like trying to shed light that we have work to do in this country.
Clearly,
we're the greatest country on earth, but we've got a lot of room for improvement.
Absolutely. And then to move over to an article from KFGO, which couldn't even begin to tell you what that is, but it's from Fargo, so that makes it North Dakota. North Dakota, right? Fargo, right?
That is in North Dakota, yes.
Excellent. Okay, so the article is, in some states, sexting could land teens in jail for a long, long time. It says 23 states. I know we cover this all the time, and I cannot fathom how we fix this. How would you identify that two 15-year-olds are sharing pictures and doing it just for exploratory reasons? They're trying to keep it private, but that, like, how would that be different than an adult and a child doing it, or adults sharing kiddie pictures? I don't like the technology is not going to discriminate between the two activities. And these laws are written from a time frame where it was not easy to send this stuff around. Like Polaroid pictures. If you had a Polaroid pictures of a teen naked, you've probably done something wrong, but you now have a whole video production studio in your pocket at all times. I don't see how we really fix this without just like decriminalizing this kind of sort of across the board. Maybe that might be a stretch, but
well, that's precisely what we did in our state. So yes, you can do that. We don't have that problem here with teens being prosecuted. They're immune from prosecution if they're doing that thing. But and in fact, we're quoted in the article, Dr. Vic Strasburger, distinguished professor emeritus, pediatrics emeritus at the University of Mexico School of Medicine.
I see.
But yes, I don't know how these lawmakers live with themselves. I don't know how they show their faces in the community when they make laws that subject kids to prosecution for doing what they did. They just didn't do it in the same way. We didn't have the capacity to show our junk and send it down the street. We actually had to take a picture and figure out some way to. In our day, we had a Polaroid camera, and you'd pull that thing out and let the film develop, and you would
wave
just
it back and forth, right?
Yeah, but this is not new stuff. And the fact that you would subject a teenager to prosecution for doing this means that you've totally become disconnected from your past and from teen behavior, and you probably need to go back to school and learn what teenagers did and have people remind you of what you did when you were a teen. I mean, this is crazy. But it's real. I mean, it's crazy, but it's real.
But do you have a sense of which states are firing these laws up versus the ones that are not? Is it? Do you think it's slanted red or blue in either way? Is it geographically located? Is it the southern states are firing this up, and the northern states, northeast, and the west coast are making it not so harsh?
Well, my bias tends to suggest that, my own political bias, but I don't know that I've got any evidence to make that assertion. The states that tend to be more liberal tend to be more enlightened on how to deal with juvenile justice issues, but that's not always a given. Sometimes economics can drive reforms, even though it's not such progressive thinking, but just simply to save money. But I don't have enough information to say that the conservative states are prosecuting kids. I can just say that we're not doing it, but I don't know which states are. But it's tragic. I mean, making someone a sex offender for sharing a nudity of themselves.
And my kid is right in the wheelhouse. I mean, in another year or two, he's going to be of the age where this sort of activity could potentially occur. And I don't I don't really care if he does it, but obviously there's this like a massive sledgehammer of consequences coming down if it falls into the wrong hands and the authorities are notified of it. You can't, if he closes his door and he has his phone and he takes a picture of his junk and sends it to his whatever partner that would become, it's out of my control. I can't do anything at that point. And then the whole law enforcement apparatus gets a hold of it and it's over.
Didn't we do an episode about a kid that committed suicide? Wasn't that something to do with texting?
Yes, that was Napier, Illinois, or whatever it was.
So, I mean, this is, to me, I could say it's repugnant and unconscionable that these laws would even exist.
Hey, Larry,
John?
whatever happened to prosecutorial discretion? And, cops, there's laws on the book against sodomy and whatnot. People don't go to prison for that. Even though it occurs in every state of this great land. I don't get it.
The sodomy laws have been declared unconstitutional, so hopefully they're not being enforced anywhere. But prosecutorial discretion is a dream. That my answer is don't give them a tool that they can use, because it will inevitably be misused. We can't trust prosecutorial discretion. In an ideal world, yes, I agree with you that prosecutors wouldn't do that. But the fact is they do that. So I'm one of those renegades when people say in hearings, in committee hearings, well, prosecutorial discretion, I say, no, we don't give them that power, because inevitably it will get misused.
You don't mean a tool like giving the Greene County in North Carolina an armored personnel carrier, do you?
I will guarantee you that will be misused at some time. It will be used in a situation where it'll be highly questionable. If they don't have that tool, they won't misuse it. But prosecutors, if they're given the tool, and our Attorney General here, who's a Democrat, is arguing for that discretion. He says, "Oh, of course you can trust me." No, Hector, we cannot trust you. We cannot trust you and all your minions to use that power responsibly and only prosecute those cases that are so egregious. But that is exactly what I rail against, is that they've demonstrated that they can't handle that discretion, because otherwise we wouldn't be having these podcasts every week.
I hear you. Well, the next article comes from NBC News. This is really, I can't, it just seems so benign of an activity. Chalking tires to enforce parking rules is unconstitutional, the court finds. That you go down to your little local city thing and you park, and some parking attendant troll walks by with a big long stick with a chalk mark on the end of it, and they mark so that it takes them another hour to walk back around. And if they see you again, then they know that you've been there for too long. And somehow this has been classified by the Sixth Circuit Court of Appeals that this is funny, that's an unwarranted search and seizure.
Well, somehow overlooked this article, so I'm going to have to defer to the other people here that did read it to come up with some intelligent comment.
The way, as far as I understand it, there's no, let's see, in the last one of the last sentences of the article, and I'm going to end up. It says taking a picture of the car or its tires without trespassing on it. That's not the one. There's it doesn't have any potential improvement in society of them marking your tire, that they are potentially putting a mark on your car that could be tracked later than just this little parking expedition that you've done. And I don't know. It just seems like a terribly benign thing, but now I guess everybody can just go down to your local city and just park, and you can just flip the bird at them and they're stuck letting you park there forever. Unless they find a different way to do it. I guess they could have traffic cams and stuff around.
Oh, well, yeah, this is a 12-page opinion.
Yeah,
I didn't read it. Go ahead.
I read it the other day, actually. One of the things I think that was part of that was that they thought the city could do, if they wanted to enforce parking, that there are other ways to do that, like meters and things like that. And chalking, for whatever reason, represented some kind of innovative method. But hey, anything that keeps the man from getting some of my money is okay with me.
So the paragraph that I found is, it says, moreover, overstaying your welcome at a parking space doesn't cause injury or ongoing harm to the community, meaning the city is wrong to argue that parking enforcement is part of its community caretaking responsibility, potentially justifying a search without a warrant. To me, Larry, this argument is, since it's a Fourth Amendment thing, I'm overly interested in having your phone be a secure device where only you can get into it, that you have secure messaging capabilities between the people that you're contacting and so forth, without some form or fashion that the police have to get a judge involved to get your information out of you. And this goes kind of along with that with, I'm sure you haven't read 1984, but it goes along with that gives the government the ability to sort of track you over periods of time.
I think you should drop this article in for next week, and I'll read the opinion.
I guess then that means I have to cut this whole segment out. Thanks, Larry, for making my editing job harder.
There's no reason to cut it out. We can just realize that we weren't prepared, and that's where people say, well, we need a better panel.
We could. We need more prep time. But then moving on to an article from Reason Magazine, and this is circling back to probably 2 or 3 weeks ago. The feds are dropping child porn cases instead of revealing info on their surveillance systems. I don't know if Reason is just catching up to us since we covered this recently. Don't really want to try and rehash the issue. But when someone ends up with some kind of child porn charges, and the government has used one of these private companies' techniques, and then the defense tries to challenge their techniques of finding out what it was, instead of revealing the information, they drop the charges. And that means potentially that they're using, I guess possibly like breaking the law in their detection techniques that might overstep some constitutional boundaries. Fourth Amendment stuff. This stuff bothers me to death.
It could be, or they could be trying to preserve the secret nature of their technology and their capacities. They don't want the citizens to know the full potential of what. If we knew all the things that the government can do to us, most of us would be so appalled we wouldn't even want to be alive if we knew all the powers that they have.
Yeah, and I started hearing, to go along with that, I'm probably going to botch it up. I hope you can help fill in the gaps. I have heard of people claiming that the government was surveilling their telephone calls without a warrant, because like information would come up in a court case that like they believed was private, privileged, and all that, but they had the information on their side, and they would try to get the government to reveal. And ultimately what came out to be like the meta tag stuff, I guess, the metadata I think that started in the Bush administration. I could be wrong. And I heard of a recent whistleblower that is claiming something similar and is currently locked up in, I think, a Virginia jail. And when asked if the government has some sort of monitoring system on the individual, they basically just say no comment.
Well, I've been hearing, I'm a talk show junkie, so I've been hearing about these capacities they have to monitor phone calls going back to Art Bell and George
exactly.
Story. I don't remember the names of all of them, but I've heard this stuff for decades.
And then to extend that, then the government built a gigantic facility in Utah to house supposedly all of the telecommunications that occur between people. I want to say even down to recording voice, which I'm going to put on my tinfoil hat. I'm telling you, encrypt your stuff so even if they do gain it, they can't do anything with it because it's all going to be a bunch of random noise. Encrypt your SMS messages. If you can encrypt your phone calls, do it, because that way they can't get to it. Done.
This seems a little, similar to tie into the SORNA Adam Walsh Act restrictions on defense attorneys being able to get access to the evidence that is so frustrating and makes it so unfair when it goes to trying to look at. I mean, the defense can't even look at what kind of images, what kind of evidence they are. In my case, I'm in Vermont. My lawyers and my consultant had to drive down to Boston in order to look at stuff. And I feel like, when the government can control all of the evidence and share it in their own confines, it's a lot like, if you're or if you're suspected and charged of murder, and you have to go and get your own forensics to do the bullet test, to do your own forensics of the site, not 2 days after, but 6 months after the crime, and they've got their analysis, which is not only is the evidence itself kept private, but the things that they use to run an analytics on it. And then what they've and then all the data and research that they've provided to the grand jury is also protected. So that at the end of the day, no wonder that 98% of people charged with any kind of sex offense is guilty, because it's completely unbalanced.
I agree with you fully on that. I've been appalled that there's been so little litigation on the provision of the Adam Walsh Act, which prohibits the defense from taking possession of the images.
Right.
They do provide the access, but it's in a controlled situation, and it doesn't give you the full potential to do your own forensics and to do your own, have your age expert. I mean, it's very restricting, and I'm surprised there hasn't been more litigation on that, because I think that we learned from Scalia that when he was on the Supreme Court, that confrontation is pretty important, and in order for you to have a full confrontation, you've got to be able to examine the evidence independently to confront the accuser about the veracity or about the validity of whatever they're alleging, and you can't do that. So I'm just shocked that there hasn't been, to my knowledge, here very much litigation. All I'm aware of is motions being filed and all of them being summarily denied, and they just simply cite to the law and say, the U.S. Attorney's Office says, Your Honor, you have to deny the motion because it's the law, and I don't think that's been taken up to any appellate level where anyone's reported a decision to me. And one of our listeners, Hank, he can do the research and let me know if I've missed something, but I'm not aware of that being litigated.
Yeah. As this one turns out, this is from WFRA, which is over on the far, far, far west coast of New York. This is actually a border town to where the company is that I do work. So I guess, so Governor Cuomo signed that sex offenders can go out and vote, but this then feels like a lower level executive branch person saying, no, that's not happening here. Despite executive order, Jamestown Public Schools will turn away registered sex offenders during budget vote and school board election. Isn't this someone overstepping their bounds, Larry?
No.
It's not?
It could be.
Okay. That's it? Okay, so then we'll move on. Just kidding. What if they say that you can't go vote and there's going to be they call it a red shirt, I think, a off-duty police officer, that you'll be escorted off the property? Doesn't this violate your constitutional right to have voting access?
It certainly seems that way to me. So the executive order, though, is what was a little bit troubling. What's the validity of an executive order? How much legal authority does that carry? I don't know the answer to that.
Okay. And then ultimately we need someone to file some sort of lawsuit after they've been harmed, or I guess would that be an injunction against this
yes.
mayor doing this? Okay.
Yes. The school superintendent, Brett, I can't pronounce that, informed the school board that he would not be giving authorization to sex offenders. So I think
that's going to be Apthorpe.
I think that he would be named, and probably the board and whoever else you could reasonably identify. But then it goes back to how much real authority this executive order has, if it's binding on this particular entity. And we would need some jurisprudence from New York, but it doesn't pass the smell test. I mean, that's clear.
Very, very good. From over in the Chicago Tribune, Cook County makes it illegal to refuse to show or rent property to people with certain criminal records. I can only guess which criminal records it's going to be. Is it going to be the sex offenders, do you think, Larry?
Probably not. They will probably not be protected.
They will not be protected. So as a property owner, the person can just say, oh, hey, on your background check, it says that you did drugs. Great, you can move in. Or, hey, you had inappropriate contact, or you had some images, therefore you are not worthy of staying on my property. Is that what I'm guessing this is?
Well, it appears to be a well-intentioned effort to make the transition from prison and with people with criminal records, even if they're not coming from prison, to have access to housing, an action taken by the Cook County Commissioners. So it's what it appears to be. The outcome is, though, it's not a complete victory because it excludes, it doesn't apply to everyone. And there's two trains of thought. There's the train of thought that if you can't save everybody, you should not save anybody. And there's a train of thought that I tend to buy into is I want to save as many as I can. And understanding politics as I do, it looks like the Cook County Board of Commissioners is 17 members. So you're trying to get to 8 to get something passed. And I'm not sure, many counties do not have an executive that has to sign things. When you have a mayor council or a mayor alderman, mayor commission type of government, usually the mayor holds the same position of being able to veto. That doesn't usually work the same way with counties. You don't usually have a county executive that can veto. Not always. Sometimes there is, but usually the county commission coming to a majority, that is the final action on an item. Since I don't know if there's an executive that holds the veto power, I know for sure you're trying to get to 8. I don't know for sure if you're trying to get to 8 plus an executive, but we can start with what we do know. You're trying to get to 8. Well, you have 2 Republicans already, Pete Silvestri and Sean Morrison, who are not for it. So that's reduced your capacity to get to 8 because they're out of the equation. And I can just about guarantee you, I just about guarantee you that they didn't say, well, I would vote for it if it included everybody. I'm just about willing to make the bet with anybody that that's not the basis of their opposition. So all of a sudden, you're still trying to get to 8. And when you're trying to get to those 8, you're running into other opposition, people saying, well, I just can't go along with that. The Apartment Owners Association said that they're reliable for renting to people who have this type of record, that kind of record, and they come in with their lobbyist and they told us that there's been a $2 million judgment awarded, and they need this capacity to turn down bad people. And through the process of this being marked up and debated and discussed and public comments, this was probably the best they could get out. So you had Commissioner Brandon Johnson, who was the chief sponsor. He had a decision to make. Did he say, well, if I can't get the whole enchilada the way I want it, I just don't want nothing, and I'm going to walk away and turn my and forget these people? Or do you take what you can get and try to build from there? That's the $1,000 question that we ask all the time, that we get criticized about, because I'm an incrementalist. If I can't get what I want in totality, I'll take as much as I can, and I'll come back and try to get more later. If I'm trying to get to $15 minimum wage and I can get the governor who'll sign 12, I'll take 12, because 12 is closer to 15 than 7 is. And if you ask the people who are working for minimum if they'd rather earn 12 or 7, I can just about guarantee you that very few are going to say, well, if I don't get to 15, I sure as hell don't want the 12. So I suspect that in the felon population, that the felon community, with the exception of the excluded people, are very happy that this step was taken. But it's unfortunate that this is probably the best that they could get through. Now, I'm not a local in Chicago. I don't know all the politics of Cook County, but I can count and I can do the math. And I know you're trying to get to 8, and I don't know how you can get to 8 without making compromises.
Fair enough. Let's go dive deep into the article itself. Comes from the Indiana Lawyer, but you've been diving over this whole the actual decision. But the Seventh Circuit rules Department of Corrections sex offender program violates the Constitution. And here's another article, Larry, that you decided to spring on me like an hour ago. I have no idea what's going on. It's all you.
The article that I sprung on you was only because it was sprung on me. It just came. It just came out on the 25th.
It says the 26th for the article, so I guess the decision came out the day before. So it's a whopping 2 days old in total.
I had a chance to read it yesterday, and I think that's when I first became aware of it. But I find this to be an exciting, and I'm going to try to stay shy of irrational exuberance, which is a word I like from Alan Greenspan, if anybody knows who he is. But this is building on an important principle of self-incrimination that's in our Constitution, and the Illinois Department of Corrections is going to have to revamp their procedures of their let's see if we get this right. What does it stand for? The INSOM program? It stands for Indiana Sex Offender Management and Monitoring Program. And this is required of everybody before they leave prison. And it requires that they incriminate themselves with their sexual history. And they face, if they don't cooperate satisfactorily, they face a reduction of their good time, which lengthens the amount of time, their statutory good time. It causes them to default on their statutory good time, which increases the amount of time they're in prison. And so that's what's so phenomenal, because the threat, it's actually a compulsory act. You have to go through this process, or you stay more time, you spend more time in prison. So that's a threat of a compulsion of the analysis, and the court said, no, you can't do that. You cannot force these people to incriminate themselves. It's a short opinion as far as opinions go, and we're going to have a link to it. What is it, 12 pages, 13 pages or something? It's 14 pages, but it's relatively short. And on page 5, to succeed in a Fifth Amendment challenge, I'm reading directly from the opinion, Lacy, who was the leader of the class, must demonstrate that the disclosures to which he objects are 1, testimonial, 2, incriminating, and 3, compelled. And then they cite the compelling authority. And then they say that the state already concedes that they're testimonial, so they don't even have to go into that analysis. And then they go in breaking down whether it's incriminating, and they go through all of what the program requires and the threat of prosecution. And these people are threatened with potential prosecution because there's no immunity for anything they say in this so-called treatment regime where they give all this information.
Right. Which totally seems like a witch hunt.
Well, it is a witch. It's my collaborative fishing expedition I've been talking about for many years. This is exactly what this is, and the required disclosures. If you go to page 7, it says the required disclosures could provide enough detail to kickstart a brand new investigation. The disclosures might advance or substantiate an ongoing investigation, or one that was halted for lack of evidence. If in current or potential prosecution, disclosures from INSOM could conform identity or modus operandi under Rule 404B too. And that's a complicated thing. I think we've had one podcast about 404B, but that's where evidence of other similar acts get to come in, even though that there was no conviction or even a charge. It's to prove that it makes you the so-called purpose is to make it more likely or not that they've got the right person. Well, if you admit that you did these things and that under the INSOM requirements, you have to disclose as much information about the victim, their name, their age, the location. Well, nothing would stop them from going back and talking to that person once you've identified them. And then that person could come in and give 404B testimony against you at a future proceeding.
Right.
And then also they point out on page 8 about a person who had gone to trial might face perjury charges because if they turn around and admit in this disclosure that INSOM requires that they did what they were found guilty of, that they testified they didn't do, then all of a sudden they've perjured themselves. So I mean, this is a phenomenally good opinion.
Hey, Larry.
And what? Yeah.
Oh, sorry. This is John. I just, is it okay if I ask the question I asked beforehand, just for the sake of the audience, from kind of a layperson's perspective?
Sure.
That was that, whether or not there's some kind of parallel here between the INSOM program where people went, and had to fill out whatever. They had to participate in settings where they confessed to these crimes and the things that they did, to the federal probation system where we have group meetings that are done with counselors who work for the federal government, report, and kind of to track not only what we're doing, but also what we're thinking and all kinds of things. And then they use a lie detector in order to kind of both try to verify that what we're doing is in compliance with our conditions, but also a lot of times to get us to confess to things that can be used to prosecute us or violate us and get us back or change the terms, whatever. It just seems the parallels are kind of similar, because here it says, based on their answers, the offenders may then be given a polygraph examination. There they will be asked such things as how many children they have molested and how many times they've made child pornography. In the Indiana case, the goal seems to be to prosecute people or find out what they're doing. And it seems very, very similar to the federal probation. So I just wonder if there's any kind of way that this translates to that, and or are they completely separate?
I see not only is it a slight correlation, I see a powerful relationship. This building body of case law is going to result in supervising authorities having to revamp their so-called treatment. Their collaborative fishing expeditions are going to have to be revamped, because if you want to do this, you're going to have to grant the people immunity from prosecution. And that's not going to sit very well with victims advocates, because victims advocates don't care about whether you get better. They care about whether you go away for the rest of your life. So if you start talking about if you start talking about immunity from prosecution, trying to do that statutorily, you're going to have every victims advocate organization on planet Earth, not even in the United States, coming in to say, how dare you consider letting these people get away with offenses they've committed against children. But that's the way, if you want to do this, and I know I get criticism for telling people if they want to do something constitutionally, if you want to do these inquisitions so you can theoretically treat these people for their whatever we want to call these impairments, their sexual dysfunctionality, you're going to have to immunize them from prosecution. If you don't want to do that, you're going to have to take this out of the picture. You can't do an inquisition and get information that you could turn around and use against them. You should have learned that in school a long time ago. Even without a law degree, you should know that you can't do that. But it's being done, and I think the federal system is going to have to revamp. I think the state systems, this is building on top of the Von Behring decision out of the 10th Circuit, which was just a couple of years ago, no more than 3 years ago. And we've talked about on the podcast about the polygraph of the threat of being incarcerated, and that was a federal case, as I recall. And
was out of California, right? Or Colorado, I mean?
Yeah, but he was on federal probation, federal or supervised release. It was a federal court, but it was also a federal case. This actually is a state case, but it's in federal court because it's a federal constitutional claim. But that we've got a building body of case law now because we've got a 10th Circuit opinion saying a polygraph that can subject someone to a reasonable fear of prosecution, you can't ask them those questions. They didn't say you can't polygraph people. And we've had dozens of people write to us and say, well, I don't have to take a polygraph anymore because of Von Behring. No, Von Behring did not say that. But they said you cannot use the polygraph to the point that it's going to force someone to self-incriminate. Now we've got an additional decision from another circuit saying that you cannot do these blatantly inquisitive questionnaires about things that they may have done without any guarantee that it won't be used against them. You just can't do it. And so I'm excited. I know people don't say we sound excited. I am excited.
Hang on, can you say that again, please?
Yes, I am very excited today to see this decision on top of the Von Behring decision that we've talked about. This is tremendous news, and I believe that it's only a matter of time that we're going to bring these witch hunts, which correctional authorities and supervising authorities are engaging in. We're going to bring some containment to them because they cannot self-contain. So we're going to have to continue try to build on this case law out of the 7th.
Does this then impact just those that are out of prison and on just supervision, where they have them take the sexual history polys and all that? Do you think that'll trickle down to this eventually?
Well, I'm not qualified to give that answer as a legal answer. I have a lay opinion that it absolutely does, because whether or not you're sitting in prison and being asked these questions, or whether you're under supervision and being asked these questions, the threat is exactly the same. You're being threatened with potential prosecution without immunity, and you're helping the authorities potentially build a case against you. So I don't see any difference in whether you're in prison or out of prison. But like I say, that's my lay opinion.
Interesting. Yeah, I mean that was while I was in treatment, that was one of my. Just the whole polygraph in general just absolutely drives me insane because it's complete pseudoscience and garbage. But I guess if they can scare you into admitting something, then the tool has worked. They could have hooked you up to a potato with wires on it, and if it scared you into admitting something, then I guess the tool worked. This is just something that has like clickety click noises and buzzers and stuff, like the game the board game we played as kids, Operation, where you would touch the sides, it would go, and the nose on that guy would go red. Anyway, that's what I think about when I think about polygraph tests.
Well, I think on page 9 that I would really like to. I think in the last 2 months we've mentioned about courts calling out duplicitous arguments, and it's clear that this court finds the state to be duplicitous. The state is saying that in its reply brief, and indeed in its reply brief, the state all but concedes the necessary level of risk is present of prosecution. It admits that there's the possibility of prosecution, but then they say, well, we've never prosecuted anybody. And the court says, well, it seems like the state is trying to have it both ways. On the one hand, it wants us to believe that the rehabilitative purpose of INSOM depends on requiring disclosures, carrying a meaningful risk of prosecution. But on the other hand, the state says, we haven't prosecuted anybody, and the court called them out for that duplicitous argument. I love it when I see courts saying, we understand that you're being two-faced here. This is a duplicitous argument. You can't have it both ways. You can't say that we have to threaten these guys with prosecution, and they have to really feel that threat, and then you can't turn around and say, but we really wouldn't do it.
Ready to be a part of Registry Matters? Get links at registrymatters.co. If you need to be all discreet about it, contact them by email, registrymatterscast@gmail.com. You can call or text a ransom message to 747-227-4477. Want to support Registry Matters on a monthly basis? Head to patreon.com/registrymatters. Not ready to become a patron? Give a 5-star review at Apple Podcasts or Stitcher. Or tell your buddies at your treatment class about the podcast. We want to send out a big heartfelt support for those on the registry. Keep fighting. Without you, we can't succeed. You make it possible. And now we're going to bring on our guest who has been here. You know, you've heard him commenting along during the show. John is an individual from Vermont who wrote us an email message and wanted to push back on some of the stances that we take where whether that be from a political point of view or on the efficacy of our efforts and so forth. And so I will let John introduce, I guess, his point of view on where his stance is on what he thinks that where we're wrong.
Well, I wouldn't say it that way, but thank you, Larry and Andy, for having me on. It's actually quite an honor. I wouldn't say that you're wrong. You're not wrong at all. I would say that I'm challenging one of your, precepts, and challenging it in a respectful and honest way. It's just a difference of opinion. It's more style, not substance. And just so let's just lay it out there, I guess. So first of all, I've been listening. This is 74 podcasts, and
this is episode 74.
And it's just amazing. I mean, I've only been listening for about 6 months, and I've been catching up. But I got to tell you, every Monday or Tuesday, I listen to your podcast, and it just cheers me up. It gives me strength. It's just really important. I cannot emphasize more importantly what you mean to me, and I know to the other listeners. And I talk to people in group because so many people, even though I've got a great support network, I'm lucky enough to have a wife. I still live with my kids. I can't talk about these kind of things. Nobody to listen. My friends, the few that still talk to me, they don't want to listen to me ramble about the Seventh Circuit appeals decision, right? But when I hear from you guys and I get to catch up on the new things, it gives me strength to go on. So, the fact that you guys do this every week is amazing, and just keep going. So, I want to say that up front. And then, absolutely.
Appreciate it.
And by the way, I am a supporter. So, I signed up about 2 weeks ago, I think, as a Patreon supporter. And, even though I can't afford it, I can't afford not to support this podcast. So, anyway, that said, what my email was simple. Is basically just I feel like I agree with you guys 100% on almost everything, and you all have changed my view. But one thing where I disagree is that I just don't have any tolerance for the registry. And I know Larry, who loves to say that it's not, the world isn't the way we'd like it to be, it's the way it is be. And
you're now famous, Larry. Just remember this.
I'm going to make T-shirts, But I understand that, and he's probably right. But I feel like since October in particular, we've had stories after stories of good news, and I feel like I just wish that there was a way that a voice that would say what I feel, which is zero tolerance for the registry. Like, I just feel like that, I don't want to give it any air to breathe. And I think that's not an unreasonable position. So, specifically, I think, you know, one of the reasons why we disagree is that, I come to the registry from only 2017. That's how long I've been there. And I think there's a lot of people who, have been fighting this fight for decades. And I get, like, if you were here during SORNA and during all these other things, periods where the courts were constantly, there was failures, like, I think I could understand how you would come to believe that, the registry is the law of the land. This is just something we need to accept, and that there is a way that it can and should exist in our lives. But I don't see it that way. I look at it more like Jim Crow laws, frankly. I think it's more, the parallel is closer to Jim Crow than it is, to some system that can be fixed. And I don't think if you were to look back at Jim Crow laws and look back at the 50s and 60s, you could see people say, well, hey, separate but equal can work as long as the separate is really equal. And I say bullshit. That it couldn't have worked then. And I think in 50 years, we're going to look back at these times, and I think we're going to say exactly the same thing about the registry, that it's bullshit, and that to the extent that we allow any arguments to say that it can exist in any form, it undercuts all of our arguments.
Yeah, I wasn't sure he was finished. Well, I tried to jot down a few notes, but the registry is not something that is effective. It's not something we support. Andy and I are adamantly opposed to registering citizens for crimes that they've committed. And you bringing this to us helps us understand that we need to sharpen what we're saying in some fashion, because it shouldn't be coming across that way, because it's not our intent to peacefully coexist. But I think I would ask you to look back at what we were talking about with the Cook County, Chicago situation. I'm of the mindset that I have to be realistic with the political situation as it exists. I don't get to decide what the political situation is, which means if I were to be a resident and a leader in Michigan right now, and that legislature is grappling with how to deal with what they're going to do with the registry, and I talked to enough lawmakers that they're, in my opinion, it'd be my guess, they're going to reconstitute some registry of some form. I doubt they're going to want to just throw hands and say we won't have a registry, because I suspect there would be a massive amount of movement into Michigan. So I'm faced with a choice. If the people that I work with say, Larry, we're going to have to enact something. Do you want the Michigan State Police to write it, or would you like to give us your version? Well, that's an easy no-brainer for me. I don't trust the Michigan State Police, because that's how we got what we have right now, which was so onerous. So I'm going to say, well, all right, lawmakers, if you're determined to do this, and I advocate strongly against registry, but since I understand politically you can't survive, in your opinion, politically without having some form of registry, you're determined to enact a more benign constitutional registry. I will do my best to give you what you're asking for. And I will give you a piece of legislation that you can defend and say that, by golly, this is constitutional. Do I believe in it? No, absolutely not. I don't believe in it whatsoever. But I'll give you an example. In our state, there was he's out of office now, but House, he was both majority and minority leader. The Republicans had control of the House for the years 15 and 16. I mean, he was minority leader prior to 15 and 16. He was majority leader, and then he did not run again for re-election in 2018. But he wanted to do a social media ban on sex offenders, and we told him you can't do that. It's unconstitutional. There was a recent circuit court opinion that said that, and I think it was out of Indiana, if I remember right. But you can't do that. And he said, well, he was a lawyer, and he said, well, Nate says, well, no, it didn't say that. He said it said that it couldn't do this one. I said, you're correct, Nate. It said you couldn't do this one. And I said, but yours is just as bad as what the court struck down. And he says, well, I'm going to push something through. He says, what do you want to do? I said, well, I'm going to try my best to kill it, is what I'm going to do, unless you decide to do what the court said, which is to narrowly tailor something. So he says, well, you write me a narrowly tailored bill. And I said, all right, I'll do that. So I said, but we're going to have to carve out a whole bunch of things. So we carved out every offender unless you had your crime of being electronically soliciting a minor. That was the only offense in the universe that required you to have a social media ban. And then we didn't have a complete social media ban. We wrote it where that you had a social media ban for only those networks that would likely have minors as members. And then we didn't say you couldn't be on the social media. We said that you could not friend a minor other than your own biological child or a child that you were directly responsible for. And I forget how far we branched out that you could friend a person. And we had the thing so narrowly tailored that not a soul would have ever been prosecuted under it. But it gave him the political win he was looking for, because he said, I want to be able to say to my constituents that I hear them, because he was getting a lot of pressure from his side saying that they needed to do something to crack down on social media where all these adults were trolling for kids. So nobody was going to understand that we had a law that was so narrow that not a soul would ever be prosecuted under it. And we put that through the House of Representatives. I testified throughout the process and got it to the House floor. And then one of the Republicans tried to hijack it and tried to put a bunch of amendments on it. And since we had the majority, we just simply killed the damn thing and sent it back to committee, and it never got out again. But did I do the right thing? Well, that's arguably, did I do the right thing? I think I did do the right thing because A, there was no social media ban, and B, if there had been, it was written by me rather than law enforcement. And I trust me to write a whole lot better than I trust law enforcement.
Well, let me just say to that, I don't think
that's where I come from.
Exclusive. I don't think that either Larry fixes bad laws or a million registrants start marching on Washington or whatever, and just to say, let's tear this shit down. It's not mutually exclusive, I think. And so to that point, I'm going to quote Jack Nicholson and say that I want you on that wall. And I want everyone who's working on fixing this, shitstorm and whatever they are to do that. But and the other thing I want to agree with, and that I want to state that you've changed my view on this 180 degrees. When I got out of jail, I thought the Supreme Court was just going to fix everything, and boy, was I wrong at that.
That's a common point, though. People reference that often, that they're going to that's our saving grace, and I don't agree with that opinion at all.
I thought we lived in a really cool democracy, and I thought that meant something. When they said there were 3 separate but equal branches of government, I actually thought that meant equal. But it means more equal Jim Crow equal than really equal. But the one thing that I totally want to give you kudos for, Larry, is your point that the real change is not going to be in legislatures. It's not going to be in the courts. It's going to be in public opinion. And I believe that 100%. And I think, while we're, the ACLU won't touch us for the most part, but, while we're fighting our little fights in, courts all around the country, and this is all important, there is no effort really to change the view that says, to the public that we are not the monsters that you think we are. And nobody actually, telling them that those champions of their children's safety that they think, the prosecutors and the law enforcement officers at Homeland Security, they're not the angels that you think they are either. And there's nobody telling the public that the laws that you think are keeping your kids safe are actually making people that are safe registrants, they were safe until you didn't let them get a job, until you didn't let them get a home, until you make them freeze in their car, and you've convinced them that they are deviant and unsafe for civilization, and became the very monster that you were afraid they were to begin with. No one's telling that story, and it's not. I don't know how to do that, but I feel fucking angry. Pardon my French. About it, I'm really pissed off. And there's an RSOL story right now called "I'm a Child Rapist," written by a guy named Joe, who's probably not his real name is Joe. But when I read that, I felt, you know, weirdly like proud to be registered for the first time in my life, and I don't know. I just feel like, I don't want to give them a win, and I don't shit. I would rather live 20 years with this shitty registry than and see it all tear down than live with it for 100 years that's incrementally better.
Well, I wish we could tear it all down, and I think that beyond my lifetime we probably will. We look back as we evolve. I mean, society does evolve in many ways. Sometimes I feel like we negatively evolve backwards, but we evolve, and I think we're going to look back on this just like we look back on school segregation. We're going to look back and say, did we do that? Did we intern the Japanese? Did we do these things? And I think we're going to look back and say, did we actually put these requirements on people after they paid their debt to society? And do we continue to humiliate them and make it impossible for them to be a productive member of society? Did we actually do that? I think there's going to be a certain amount of shame that we did these things. But it's going to take some change in public opinion before we actually get to that point. And there are people like Lenore Skenazy who's doing the very things you say about she's pointing out with her. It's not even called free range kids.
It's called Let Grow.
Whatever she calls her Let Grow. Okay, she's pushing back, saying some of the things you're saying, but it is being those things are being said, but they're not being covered with the same intensity of what's being said from the other side. Our Attorney General, if he breathes anything about keeping kids safe, I mean, he gets a lot of attention in the media because he's trying to protect kids. If the advocacy organizations that claim that they're fighting for victims, if they breathe, they get covered. If we say anything about about the oppression that's happening and how that it's tearing families apart and destroying the futures of kids, I mean, kids suffer because of their parents being on registries. They suffer enormously in terms of being isolated and ostracized and even physically abused.
Yes.
They get attacked because of their parent being on the registry.
But then to flip that back around, if we had a quote-unquote registry like was in Alaska in 2003, we probably wouldn't be having this conversation at all because other than it being on the internet, and the internet is not what it was in 2003, it wouldn't be, I don't want to say it wouldn't be that big of a deal, but it wouldn't be that big of a deal because there weren't restrictions, there weren't things that debilitated you from functioning.
Well, I think the internet's going to be the Achilles heel of the registry because the analysis no longer applies. The internet has become so pervasive in life that even if you look at the Connecticut Department of Public Safety versus Doe decision when the Supreme Court last looked at that, the internet was nowhere near what it is today in terms of the impact it has on a person's life and the availability of information. So I think that the courts may someday conclude that the public dissemination via internet is punitive and can't be done, the courts may be able to save us on that. But then we would be back to that they still could have a registry that would be non-public, which I still wouldn't support. But it would improve people's quality of life, which is what I'm trying to do. My goal for the remaining time I have is to contribute as much energy as I can to improving the quality of life of people who are having to live this. And I will take every increment I can get to improve their quality of life, because it's an improvement over the status quo, just like that miserable removal process that California created. That's going to remove very few from the registry. It is a pitifully small first step.
Right, but let me leave you with one thought, and that is, remember the '90s, right? Remember when they really exploded, and with AIDS and Magic Johnson and basketball players afraid to play with them, and Ryan White. Back then, okay, I remember it, but it was socially acceptable if you were at a barbecue and somebody came up to you and said, "Hey, I just believe that AIDS is God's answer for homosexual sin," right? Now that's just unthinkably, like, ridiculous. But then that was what people said, people believed, and it wasn't scoffed at. What happened between then and today is, I think, a lesson that we could learn from, and that is that the way they flipped the script was they came out like everywhere. Pretty soon it was like your niece and your uncle and you're the guy in the next cubicle, and like it was everywhere. And we have 1 million people who are registered, and we're like being gay in the 1940s. We're high in plain sight, but we don't want anybody to see us, and for good reason. But I think if everybody knew the people were actually registered that were in their lives, I mean, there's 330 million people in America, half of which are women, right? And of the kids, so you're talking almost 1% if you consider registrants are males, right? You're talking about 1% of all men, almost, are registered. And, I don't know. It's just, I think that if you want to change public opinion, you need to think of ways to do it. And I think, the ways to do it are, look at the way other minorities who've been marginalized have done it.
I agree with you to a point, but not completely. I agree with you that's what helped change public opinion. I agree with you that public opinion changing is what caused us to be where we are on that level of civil rights. But where I disagree with you is that we always understood you didn't choose your race. We began to accept that you didn't choose your sexual identity. There are people who still believe that it's a choice, but I would say that significantly more don't believe it's a choice. They believe that it's what you are. I haven't gotten a whole lot of people convinced that you don't choose to commit the sex offense. So this is ostracization, if I can pronounce it, based on something that you've done. And that's different. Yes, and I think that we're going to have a lot harder time getting that same diabolic shift of public opinion. And I don't say it's impossible, because we're going to have to go at it from a different angle. We're going to have to go at it from the angle, you do believe that a person, after they've paid their debt to society, should be restored. And almost everybody will universally say yes. And you say, well, why are we having them go to a police station to be detained and to go through all these barriers of voting and can't go see their kids play ball? Why are we doing that to them and not allowing them to rent apartments? You just said you believe that a person should be restored, and we're doing all these things to people. I think that somehow we're going to have to connect those dots, and we're not doing a very good job of that. People think that the registry is a part of your punishment. They don't realize it goes on for decades and sometimes the rest of your life,
right.
Many times the rest of your life.
Yeah, but to your point, you don't choose to be, gay. You don't choose. You're born that way, and you don't choose to be black, obviously. But a lot of us didn't choose to be assaulted when we were kids and or sexualized. I mean, I haven't met a sex offender that wasn't sexualized when they were a kid. And regardless of what, because I think we all come to this place from different angles. But regardless, we're all made. There's no 5-year-old that you can look at in the sandbox and say, "This guy's going to grow up to have a session for 10-year-olds or boys," right? That's just ridiculous. Like, we are human made. Like, for the most part, men have made us into what we are, one reason or another. And so I don't want sympathy, but the real point is that we committed a crime. Okay, I certainly did, and I did my time, and I'm doing probation with a happy smile on my face. But the rest of this is bullshit, and that's it, right?
And I agree with you completely on that. The registry is of no use, and it's horrible that we're doing this to people. And I wish I could end it in my lifetime.
I just want to throw out the Andy role on the show. The Andy role is, I am not like, I barely knew civics when I first stepped foot in prison, and through listening to radio and other programs, I started to like figure out, hey, there are 3 branches of government, and tried to start figuring out how those things work. Listen to a lot of conservative talk radio. But the other, so like for me, this is Larry essentially teaching me how this all works and what would be effective in moving the ball forward, where you would have different arguments for the different political sides. The other thing that I'm here to do is say crazy, stupid stuff that will jeer somebody and get a rise out of them. That's totally my purpose in this world.
It is?
Yes, I'm totally here to say things like medulla oblongata and get you to go, the what? That's my purpose.
I still don't know how to pronounce those words.
It's good times. And John, I just want to tell you that someone in the chat has said you say shit a lot. See, that's me trying to get a rise out of somebody.
Yes, and I gave him a poop emoji.
A what?
You don't know the word emoji, Larry?
I know emoji.
It's Japanese. Don't worry about it.
It's an icon. If you look in the chat, you'll see a little piece of poo out there. Anywho, what else do we have to cover before we shut this mother down?
Well, I'm looking forward to getting more out on the GPS, the story of the DePark case in Georgia. That's a building body of case law on that, thanks to the Grady decision by the U.S. Supreme Court. And I think we're going to see that body of case law where they're just indiscriminately putting GPS requirements on everybody because they have a conviction. So the next NARSL in action conference call, I'm going to try to have the attorney from the Georgia case on, and we're going to try to talk more about GPS monitoring. And I think we could certainly do that on the Registry Matters because it's a thing of great interest to people. If you
will
have
will the next NARSL in action be like in 6 months from now?
I'm hoping it'll be a little bit sooner than that. We
I'm picking on you.
We had a period of not having any. It seemed like that the attendance had kind of flatlined and was declining, and that I wasn't getting a lot of support from the states to promote it. And I decided that it's put so much energy putting one of those together because people don't realize that you're trying to schedule content, something intelligent to talk about. You're trying to fit at a time for a guest. You're trying to figure out a time and a time slot across the country where you can have maximum listenership. And then you're trying to ask intelligent questions, which means you have to research the topic. And I usually prepare the questions in advance so that they know how to prepare to give answers. And it's a lot of work in trying to build the script to promote the podcast, the conference call. We usually send out 2 or 3 promotions and try to get people signed up. And if I'm doing all that work and there's going to be 30 people call in, it's like, really? It's just not worth the effort. But well over 100 signed up and over 100 showed up. So the last one, it seemed like that the interest is there. And I don't know if it was because of the content or because of the long time of not having a call. But the content was very exciting because we were talking about keeping people in prison after they've served their time, which is what a lot of states are doing. And that's what we're doing in my state. That's what they were doing in Illinois. We are doing in my state. You essentially get 2 sentences when you're convicted of a sex offense here. You get a period of incarceration if you don't get probation. But the period of incarceration, if you do get incarceration, is followed by a period of what we call parole. But it's in addition to your prison. It's a separate sentence, and it's an indeterminate period of either 5 to 20 or 5 to life. And here, if the parole board doesn't improve your residence, you stay in prison. Well, in Indiana, if the prisoner review board, the PRB, doesn't approve your residence, you stay in prison. After you've done your entire prison sentence, you still stay in prison serving your period of supervised release, as they call it in Indiana, parole as we call it here. That is unconscionable in this country, that we could tell a person, you've got 12 years of prison. You served the 12 years, and we're going to put you on 5 years of community supervision. Oh, you're going to propose to live at this? No, you can't live there. Oh, well, then do you have an alternative? No. Well, then we're going to keep you in prison. Well, wait a minute, I finished my time. We're going to keep you in prison. If the state doesn't like the address that the person's proposing, it's incumbent upon the state to provide an alternate address, in my opinion. And that's what we're going to work towards here, is getting these people relief from incarceration. And now that the hard lifting has been done in Illinois, we're going to poach and plagiarize and do the same litigation here. So, but I think that may have been what caused so many people to show up, was that it's quite a topic when you're talking about having people serve their time and then keeping them in prison after they've served it.
Well, I guess we have a lot of work to do, I guess is what we should really ultimately say. We have 50 state registries to try and tackle, some of them being easier than other ones. Wink, wink, John, that's one of yours. And then there are some that are like, I mean, to quote John, like they're shitty. But, you know, they're individual issues that we have to fight at each different state. But as you keep pointing out, like it feels like since we've been doing this, it feels to me like there has been a larger amount of things coming and just even coming and then even decided in our favor. And what you keep saying is we're building a body of case law that we could then take bits and pieces and replicate and go to the other states and have further victories over there. This is
just great momentum we're building. And the thing that always I try to say without letting people down is they won't run out of creative ideas, those who want to do bad things. If they were going to, there wouldn't be any American Civil Liberty Union after 100 years. They will always be able to come up with bad public policy, and then some of that bad public policy will trample constitutional rights. There will always be a need for an arsehole. If we succeed in getting the registry to either abolished or totally private, they'll still be doing the things we're talking about now: the polygraphs, the collaborative fishing expedition, the ridiculously long sentences, the sexting. I mean, we won't run out of things to oppose.
No, we will not. We will not run out.
So it's like interruption of the prison mail, no visitation. They will not stop. So there will always be a need. And I could say what would make people happy. We're going to have this enlightenment period where everything's going to be hunky-dory and there won't be any more bad public policies formulated and we can just close up shop and go home. I don't see that happening because that's just not the way we're flawed. We're going to continue to do misguided stuff. So there'll be a need for an arsehole to be fighting something. No matter what it is, there will be something for an arsehole to do.
Well, the chat has completely devolved into sending just crazy, silly GIFs and memes and so forth like that. So we should probably call it quits.
The chat has done what?
They have devolved. They have devolved into complete chaos and silliness. Oh. They are putting silly pictures up there of cats trying to make it through cat doors and they're too fat to make it through and teardrops falling. It's out of control. These people are nuts and we should send them on their merry way because they're having too much fun in chat. We can't have this.
Well, then how do people support and get to know us and contact us? I think we should encourage people to do all of the above.
We should have them send smoke signals. They could just build a teepee out back and they could, make smoke signals and that would get in contact with us.
All right. So how many signals would I send up?
Well, the first one that you would send would be go to the website, registrymatters.co. And there you can find show notes. You can sign up for email alerts. There's something in here that I'm trying to remember. When the podcast gets released to the general public, if you want to know, I always forget to mention about the email alerts. If there's about 50 or something people signed up to get those, if you want to get notified when it gets released, you go there and sign up. Your favorite method, I think there was a voicemail method. I was just too busy to try and put this one together. Leave us voicemail message, 747-227-4477, and that's not 737 because those have a tendency to not stay in the air. So it's 747-227-4477. Email us at registrymatterscast@gmail.com. And of course, we love all of our patrons. We love all of our listeners, but the patrons are helping keep the show going and show appreciation, and that is patreon.com/registrymatters. John, unmute yourself so we can say goodnight. Larry, what do you have?
Well, you're being funny about smoke signals, but I do believe, and I'm not Catholic, so I'm not sure about this, but I do believe that when they select
they totally do. They totally do.
I believe they still send up a smoke signal.
I was watching that. When was the last one? Like 2010 or 11, somewhere in that ballpark? I remember seeing that going on.
Yeah, they open up the chimney and send up the smoke.
This is correct. John, thank you very much for being a super gracious guest, and thank you very much.
Thanks for having me.
For being a supporter.
Yeah.
Supporter
Are you
of
kidding?
us.
Forget about it.
And for your heartfelt comments. We appreciate the constructive feedback.
Well, thank you for hosting them. I appreciate it.
And with that, everyone, have a great night. Chat, try to wrangle yourselves down and not be so crazy over there. And we will talk to you guys soon. Have a great night.
Night.
Bye.
Thank you for listening to the FYP Network.